Hi, I'm Derek Watkins from McKenzie Friend Consultants and welcome back. In today's video, I'm going to be giving you top tips of how to deal with barristers in the family court. Now, as someone that's represented themselves in the family court, you're going to be unfamiliar with the process and the whole procedure is going to be feeling somewhat daunting for you. And then if you then hear that your ex is being represented by a barrister, your anxiety levels are going to go much higher and you're going to be feeling somewhat disadvantaged. The reality is that having a barrister represent them is going to be giving them a big comfort factor because they haven't got to worry about everything. And you're going to be feeling somewhat disadvantaged. Now, it is going to give them a comfort factor, but it's going to be a very expensive comfort blanket, to say the least. It's only natural to feel intimidated and disadvantaged, and you've probably considered whether you can afford representation yourself to level the playing field. Well, let me assure you this, you don't need to be paying tens of thousands of pounds for hotshot lawyers in the family court. So, how do you deal with this situation? Now, one of the first things you need to do to give yourself a fighting chance is to get familiar with the family court process before you even go to your first hearing. You need to educate yourself on the family court and the family court proceedings. And one of the best places to educate yourself is right here on my YouTube channel. All you have to do is subscribe and you will have access to 30 short videos covering most aspects of the family court process. And the better news is that it's entirely free for you to view whenever you like. The barrister will almost certainly introduce himself at the hearing, and it's your job to do so. They will speak to you before the hearing starts. They'll explain to you what's going to happen during the hearing, what the issues are as they see them, and what they're going to be asking the court to consider and order. They will assume that as somebody that's represented themselves, that you won't be following what they're telling you and that you won't be confident enough to challenge them in the court hearing. Now, unless you're very careful, this is what's going to happen in the hearing. They will tell you these matters as if they're a fait accompli. Now, you must question them, ask them to explain anything that you don't understand, and inform them of each point that you disagree with. This is really important. And at the same time, you should make a note of these points that you disagree with so that you can refer to them during the hearing. When the hearing starts, the judge will probably turn to the barrister and ask the barrister to summarise what the issues are and where the parties are on those issues. The barrister will then take over at this stage, go into great details what the issues are and what he or she believes the court should do about those issues, and assuming that the judge will go along with him. Now, that may well happen. The judge should come back to you and ask you for your views on those, but due to time pressures and other matters, that often doesn't happen. Therefore, it's really, really important that you have your say and you give your view on the issues. So, when a barrister has made a point, if you don't agree with it and you have a different view you want to give the court, then you must get the judge's attention by holding your hand up. The judge will acknowledge you and will come back to you and ask your view. And you must do this on every point that you disagree with or you want to make your point on that matter. So just keep raising your hands And after you've done that a few times, the judge will automatically come back to you. Okay? If you don't do that, what will happen is the judge will go along with the barrister. The hearing will be over. You haven't said a word. You don't really understand what's happened. And you certainly won't have got the outcome that you desired. So it's up to you to make sure that the judge hears your side of things and your points. At the end of the hearing, the barrister and the judge will start to discuss the order. And the judge will ask the barrister if I would kindly draft the order on behalf of the court, which is perfectly normal, unfortunately. What is also perfectly common is for the barrister to use, how should I say it, poetic license, so that the order is slanted in their client's favour and may not be a true representation of what exactly happened during the hearing. I therefore strongly recommend that at this stage you put your hand up and you ask the judge, would it be possible if the barrister would draft you a copy of the order before it's forwarded to the court? Now, judges are used to this, and a good judge will say it's absolutely fine. Turn to the barrister and say, please make a note on Mr. Rich's email and send them a copy of the draft order. But I do want it by XYZ date. Okay. Sometimes the judge will say, well, it won't be necessary because I'm sure the barrister will do a good job on behalf of the court and it will be an accurate draft order. In that case, the judge is aware that you have a concern and will pay closer attention to the order. Finally, if you're up against a barrister in the family court, I would strongly recommend using the services of an experienced McKenzie friend. I'm not saying this to drum up more business. I'm saying this to level the playing field, as a good McKenzie friend will know how to deal with barristers because they deal with them on a daily basis. And if you do need further assistance with your case and you live in the south of England, then please go to my website www.McKenzieFriendConsultants.co.uk and book your free consultation with me. That's it for today, and until the next time, thank you.